Hey everybody, Rich with Prep You down here outside the bunker. Hey, so if you haven't heard already, a judge in Effingham County, Illinois, approved a temporary restraining order on the Protect Illinois Communities Act. Um, but don't get too excited. Doesn't mean it's going away. It's not going away. This is a procedural TRO. Okay, what is a procedural TRO? Well, we'll talk about that in a second. But basically, the judge, Fourth Judicial Circuit Judge Joshua Morrison ordered this TRO regarding this House Bill 5855 and issued a temporary restraining order. So here it is, all 11 pages. But let's get into a little bit about what it does and what it doesn't do, really. Okay, remember, this was the first lawsuit issued in the state of Illinois. I believe currently there are four going forward. This was from Tom DeVore, filed in Effingham County, and totally procedural, basically going keen in on the procedural rule that it had to be read three times in the House and Senate before it could be passed, and there were some procedural issues. So, what it specifically says is um, in a response to a lawsuit that alleges Illinois lawmakers violated the state constitution in passing a law to ban certain semi automatic weapons. A circuit court judge in Effingham County Friday ordered a temporary restraining order on the new law. The ruling only goes into effect for the 866 plaintiffs involved in the suit, which includes gun shops and gun owners from across the state. I don't know who those 866 are. I really don't. I could always ask for your help. If you know who those 866 are, then that would be great. This goes into effect immediately until the preliminary injunction hearing set for February 1st. Okay. And probably why, if that hearing's more than one day, the TRO stays into effect until they figure this stuff out. The Fourth Circuit Judicial Circuit Judge John Morrison ordered that any administrative agency or law enforcement agency should not enforce any and all elements of the law regarding the plaintiffs in the lawsuit. So, what does this mean? Does this mean that if your favorite firearm store was a plaintiff in this, can they put the magazines back out? Can they put the rifles that carry more than 10 rounds and the pistols that carry more than 15 rounds? Can they put them out? I think so. I'm not a lawyer, never have been, never will be. Can they put those out? I'm guessing probably yes. I suppose what I would do if I were you, I'd go to your local gun store and see if they're out. Um, he said this court finds that the defendants unequivocally and egregiously, that would be the state, violated the three reading rules of the Illinois Constitution in order to circumvent the constitutional requirements and avoid public discourse. Morrison wrote in his 11-page order. This court finds that due to the blatant disregard for constitutional law, the plaintiffs, which was Tom DeFore in the 866, the plaintiff is likely to succeed on the merits of this claim. And what they mean by that is you get a TRO if the judge thinks that, yes, this case has merit, but we are going to have a temporary restraining order until we can have a court date. February 1st is the court date. So they're saying you cannot proceed with any of this until the court date. Attorney General Kwame Raoul, we disagree with the court's decision. We have filed a notice of appeal and will ask the appellate court to reverse and vacate the TRO. So here come the games. Here's the tennis match. We'll see what happens with the appellate court. J.B. Pritzker said this decision is not surprising, although disappointing. And of course he goes into the whole things that Illinois people should feel safe in their, um, front yards and schools and why eating at bars and restaurants. Well, we would feel a lot safer if we were able to carry in at school, at bars and at restaurants and in public transportation. We'd probably feel a whole heck of a lot safer. Um, so actually, I said earlier, House Bill 5855, I was incorrect. It's House Bill 5471 is what he um, ruled on. So, what are the constitutional arguments that he brought up in this? Well, he said that this law violates the single use rule of the Illinois Constitution, according to the lawsuit. And when I say constitutional arguments, I'm saying Illinois constitutional arguments. Okay. Second, Morrison stated that the plaintiffs have raised a question that has a fair likelihood of success of proving the defendants violated the single subject required by choosing an overbroad original title that was used to allow them to circumvent the normal legislative process. And what he means by that is it was put in the Carnival Ride Protection or whatever act, or covering slides at playgrounds and stuff like that. That's what he means by that. It also violated the Equal Protection Clause of the Illinois Constitution, according to the suit. And what he means by that is equal protection because it's said in the law does not apply to some people, including law enforcement officers, qualified retired law enforcement officers, and members of the military while performing their official duties. It also brought up the fact that it didn't cover wardens and people that work at jails and stuff like that, which is not equal protection for you and me if you don't do any of this stuff. It also violated the three readings clause of the Illinois Constitution. The lawsuit alleges the Senate read the amended bill once, and then it was not read at all in the House the second time around. All right. Then also, he wrote that due to the blatant disregard for constitutional law regarding the three reading clause, the plaintiffs likely would succeed on this allegation also. And fourth, the law violates the due process clause of the Illinois Constitution, according to the lawsuit. Attorneys for Pritzker and Raoul raised several issues against this allegation, but Morrison wrote that the plaintiffs likely could prove the General Assembly did not follow due process clause of the state constitution. In oral arguments, the defendants stated that the only procedural right which plaintiffs are afforded is the right to raise their argument in court after legislation has been passed. This argument is particularly concerning to the court, implying that the legislature has the right to pass any law that it deems fit without regard to the constitutionality or procedural process. Okay, this does not at all have anything to do with the Second Amendment of the U.S. Constitution at all. This is purely procedural. It's a great step. It's a step in the right direction. But beyond that, the other lawsuits, the lawsuits by ISRA and the Firearm Policy Coalition, some businesses, private organizations, and a group of individuals, actually addresses the Second Amendment. It's a federal lawsuit. So, temporary restraining order, good. We need to go further. This is just step one. So, Illinois State Rifle Association, who is involved in the federal lawsuit, sent out this little notification. ISRA applauds Judge Joshua Morrison's ruling this afternoon. This is a clear indication from the court that the General Assembly and Governor Pritzker rammed this law through improperly. The ISRA firmly believes the law is an infringement on all law-abiding residents' Second Amendment rights. We look forward to the proceedings in our federal case, and we will keep a close eye on other cases as well. And like I said, there are 4 of them. So let's look a little deeper. And the question here is really, will this case go to the United States Supreme Court? Probably. Let's face it. If the state wins, being the defendants, the plaintiffs are going to take it all the way to the Supreme Court and get this answered once and for all with what are the states' rights in regards to the Second Amendment. If the plaintiffs win, you know that the states are going to take this all the way to the United States Supreme Court. So, you know, this is why I believe it will probably end up there either way. And it needs to end up there. It needs to be answered once and for all. Can the states make requirements on the Second Amendment? Which I always thought that if it was in the Constitution and under the amendments, states couldn't affect it at all. That's basically if we look at Roe versus Wade, that was not should not have been in a federal court. That's a state rights issue. It's not in the Constitution, so they don't have any right to rule on it. That's why it was overturned after 50 years. Let's face it. Some of these cases have gone before the Supreme Court, and they've kind of like just let it, yeah, whatever, or haven't taken it up at all. But as I said, filed on Tuesday was Harrell versus Raoul, based on federal laws, ISRA, Firearm Policy Coalition, businesses, some private organizations, and a group of individuals put forth the case that PICA, or Protect Illinois Communities Act, violated the Second Amendment. This case on Wednesday was assigned to federal judge Stephen P. McGlynn. The plaintiffs are seeking a temporary restraining order or preliminary injunction on the federal level, just like the other one with Tom DeVore is on the state level. To get this, they must prove that there is a likelihood that their case will succeed in trial. And we talked about this with the other one, is you can ask for a temporary restraining order and the judge will look at it, and if he says, oh, well, they got a good case, he can throw a temporary restraining order. If the judge goes, I don't know, you can bring the case forward, but I don't think you're going to succeed, no temporary restraining order will go into effect on something like that. A lot of people have talked that, well, let me just read this. Those of you who remember the New York State Rifle Association versus Bruin went to the Supreme Court and held that the appellate courts have been applying the wrong legal standard when it comes to firearms. That's what was in there. If you remember that this was a concealed carry shall or will law, and New York was it wasn't a shall order state. Now it is, although they have just recently made some changes. The Supreme Court stated that the proper test for assessing infringement on Second Amendment is whether the government can affirmatively prove that its firearm regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. All right. Then, regarding modern firearm technology, SOTUS directed the lower courts must prove that, as a matter of history, a similar ban or regulation was viewed as constitutional. All right. So think about it this way. Think about when the Constitution was written and ratified. What was the historical everyday firearm that people had? It was a musket. Okay? So as you go through history, technology changes. As technology gets better, the firearms got better. Today, we can go all the way up to today. I'm going to back up a little bit, but we can go to today, and you can see that what they call the assault rifle, I like to call it, the AR or AK platform, is today's musket. Okay, it's very popular. There's millions of them out there. We consider them a modern sporting rifle, and everybody has them. So it's not outside the bounds of what a firearm should be covered under the Second Amendment. That's what the court said in the New York case. Okay, it was, many states had constitutional carry, other states had, um, shall carry, and New York didn't, and that was outside the bounds. Okay, so now let's go back to the 1930s. The case against automatic firearms, something that was really well that people in the gangster business, shall we say, like to use were Browning automatic rifles, very fun rifle, and Thompson submachine guns. Well, they were banned because they were outside the bounds of what's considered a common firearm for that time. Okay, common firearms for that time were revolvers, were also bolt action rifles and stuff like that. So that's why they weren't affected. So we could read on. SOTUS held that the proper clause requirement prevented law abiding citizens with ordinary self defense needs from exercising their right to keep and bear arms, and was therefore unconstitutional based on the history and tradition. And that's what they're talking about in the New York case. Um, Concealed carry is not outside the bounds. Okay. Just like the way I look at this, the way I read this, put this forward to the 2A case about assault rifles, is it's not outside the bounds. Most people that shoot firearms, most people that have rifles do have the AR-AK platform. It's a common rifle. It's just a common rifle. So um, that's, where they're at with that standing. Um, so under, if you look at the Bruin standard, the Seventh Circuit and SOTUS will likely find the Illinois ban on assault weapons unconstitutional because the status banned type of firearm commonly used for a lawful purpose. It is. It's a common rifle used for that. And that, and SOTUS also said that you cannot use societal concerns or dramatic technological changes cannot be used to determine law. Okay. You cannot use these mass shootings, these gang shootings. You cannot say that, hey, this is the technology in these rifles is so much more than our founding fathers would have ever thought could have ever been possible. Um, I have a feeling they probably figured that there was going to be a lot of technological changes in everything. They didn't think about computers, they didn't think about flight, they didn't think about any of this stuff, but as life goes on, technology changes. Where the Supreme Court said in the New York case, you cannot use societal concerns, i.e., mass shootings, stuff like that, or technology changes, semi-automatic rifles and pistols and stuff like that, to determine law. All right, so that's why I think that if it gets to the Supreme Court and if they stick with it, it will be once and for all taken down that you cannot have these bans on assault weapons, okay? Or should I say, modern sporting rifles that hold more than 10 rounds and are semi-automatic. All right, so that's my feeling, and I think quite a few other people's feelings on how it will go. But what about magazines? Magazines are a totally different thing because there's two things of looking at it. For magazines, like common firearm ruling, magazines holding more than 10 to 15 rounds are also prevalent. They're very common. Everybody's got them. Matter of fact, there's more magazines out there than there are firearms. Okay, prevalent? Yeah. Modern technology? Yeah. Is it outside the bounds? No. But here's the other half of it. Two courts have held that magazines are not arms within the meaning of the Second Amendment. So what they're saying is the Second Amendment does not cover magazines. I don't know. Again, I'm not a lawyer. I don't know which way this is going to go on that, but I truly believe that using the New York case from the Supreme Court and the different things that they brought forth in that, and saying that the lower courts are using the wrong criteria to judge these laws against the modern sporting rifle. And I'm going to guess, I would assume, magazines, that these laws from different states will be struck down, and maybe once and for all, we'll get the state out, out of the business of backdooring the rights of the Second Amendment for individuals, for sporting, for competition, for hunting, for protection. So there you go. Bottom line is there is a temporary procedural restraining order in Illinois currently. Whether, I don't know exactly who it affects. It sounds like it affects a whole bunch of people if it's 866 people, or organizations, or businesses. Um, like I said, I haven't been able to find the list, but might be worth a trip to your local range and gun store to just see what's hanging out on the walls, and if there's bins of magazines out there. Um, and you have to, if that is the case, right now you got till February 1st to put your orders in and buy whatever you want. So I am really glad, if this, if one of the plaintiffs was Range USA, that I'm not working this weekend, because it's going to be nuts there. So, but that's it. That's the latest on the Protect Illinois Communities Act and the legal actions, and I will keep you posted. Please pass this on to anybody you know. This is fantastic news. Um, I hope you're glad to hear this stuff, and take care. Carry on. We'll see you next time.